Mayong adlaw kaninyong tanan. Assalamualaikum warahmatullahi wabarakatuh. This pre-recorded video is the second episode of our subject, CDI3 Specialized Crime Investigation. In this episode, we will tackle your first research assignment, the constitutional rights of person arrested, placed under investigation, search, and seizure. This is a very interesting topic considering that the issue highlights critical concerns within law enforcement practices as deviations from proper arrest protocols, whether through warrants or warrantless apprehensions, may lead to legal consequences for officers. At its core, the Philippine Constitution mandates strict adherence to due process, emphasizing the fundamental right of the accused. Ensuring consistency in arrest procedures is not merely procedural, but a constitutional obligation safeguarding both justice and individual liberties. First, we will define we will define arrest under Rule 113 of Criminal Procedure. Arrest is the taking of person into custody in order that he or she may bound to answer for the commission of an offense. It involves restraint of liberty effected by an actual restraint of the person to be arrested or by that person voluntarily submission to the custody of one with authority to make the arrest. Every person has individual liberty. You cannot deprive his or her freedom unless you have valid reasons to restrain and apprehend a person, but of course, it is always in accordance with the existing rules of criminal procedure. Next is we will discuss the arrest with warrant and warrantless arrest. We will define what is warrant of arrest. Warrant of arrest is a judicial document issued by a judge authorizing law enforcement to detain a specific individual suspected of committing a crime. Meaning to say, a warrant of arrest is a document issued by a judge directing law enforcers to arrest and detain a person into custody. Question: Is the warrant of arrest has expiration? The answer is generally the arrest warrants do not have an expiration date. They remain active indefinitely until the suspect is arrested or the warrant is formally withdrawn or quashed by a judge. Now, we will talk over about statute of limitations in the Philippines, or the SOL, no? Also known as the prescriptive period. Prescriptive period dictates the maximum time allowed to initiate legal proceedings after an event. No? This period varies significantly depending on the type of case, whether it is civil or criminal, and the specific offense involved. failure to file a case within the prescribed time frame generally bars the claim permanently. Later, as we go on with our discussion, we will learn what are those statutes of limitation or SOL, or the so-called prescriptive period. For civil case, for example, breach of contract or torts, civil wrong, the prescriptive period often has a 4-year limitation period. Claims related to real property may have longer period. That is for the civil case. For criminal cases, lighter offense might have shorter periods, no? 1 to 2 years. Example of lighter offenses such as physical injury, unjust vexation, oral defamation, trespass to dwelling, and etc. More serious crimes, such as those punishable by death or life imprisonment, often have no statute of limitation at all. This means they can theoretically be prosecuted indefinitely. For example, murder, espionage, treason, kidnapping resulting to death, aircraft hijacking resulting in death, and terrorism resulting in death. Those are examples of crime often have no statute of limitations. They will be prosecuted indefinitely. And the last but not the least is the crimes punishable by reclusion temporal. Typically, crimes punishable by reclusion temporal have a 20-year limitation. For example, no, like kidnapping and serious illegal detention under Article 267 of the RPC, slight illegal detention and under Article 268 of RPC, homicide under 249 of the RPC, robbery with physical injuries under Article 294 of RPC, and acts of lasciviousness with force under Article 336 of the RPC. Those are examples of crime punishable under reclusion temporal with spans of 12 years and 1 day to 20 years, and carries accessory penalties like perpetual absolute disqualification from public office and suffrage. So, based on our discussion, the statute of limitations or SOL, a key principle appears. If the accused remains at large or not apprehended beyond the prescribed statutory period for the alleged offense, except those serious crimes punishable by death or life imprisonment, the charges must be dismissed by the court. So, ganyan pala, no? As the expiration of the limitation period legally bars further prosecution. This is now the consequence of missing the deadline, failing to initiate legal proceedings within the applicable statute of limitations generally results in the permanent dismissal of the claim. The aggrieved party loses the right to seek legal remedies. No? For 20 years pa naman, hindi talaga nahuli ang suspect. And there are several reasons bakit ito nangyayari. Siguro, talagang magaling lang magtago ang suspect or the aggrieved party or the victim kulang ang pagpapalo up sa kaso. Sometimes we as complainants, no, have also an obligation to follow up the case that we filed in court or even the prosecutor's office kasi marami talaga silang inasikaso ng mga kaso. Kahit nga in my part as an investigator, no, in my own experience, no, nagkakaroon ako ng isang dismissed case sa fiscal level pa lang, napakatindi kasi sa dami ng na-endorse ko na kaso, ito lang talaga ang na-dismiss, no? At very annoying sa part ko as investigator kasi sa PNP, once may nadi-dismiss na kaso, you are subject for pre-charge evaluation. Kakasuhan ka ng administrative case at pwede kang ma-dismiss sa serbisyo. So, ganun kahirap ang maging isang police investigator. Although it is beyond my control, pero wala akong magagawa. Hintayin ko na lang kung ano ang magiging resulta ng MR namin. Ang importante, nanindigan tayo kung ano ang tama. Kahit aabot pa kami sa Supreme Court, hindi ko talaga susukuhan ang kaso na yan. So much for that. We will also define warrantless arrest. So tapos na tayo sa arresting a person with valid warrant of arrest. So now, we will define warrantless arrest. Warrantless arrest is the apprehension of an individual by law enforcement without a prior warrant issued by a judge. So, kabaliktaran lang ang definition sa warrant of arrest. This time, ang apprehension is walang warrant of arrest issued by a judge. Under Rule 113, Section 5 of Criminal Procedure explicitly details 3 situations where a warrantless arrest is lawful. Number 1, in flagrante delicto under Section 5, Paragraph A of Rule 113 of the Criminal Procedure. So ito yung tinatawag na caught in the act, no? It states that when the person to be arrested has committed, is actually committing, or it's attempting to commit an offense in the presence of the officer and private person. Ano ang ibig sabihin nito? Uunahin natin ang phrase na the crime committed within the presence of the officer and private person. The officer na tinutukoy dito is the law enforcer or yung police, no, mismo. And the private person is civilian, no? Civilian like you. For example, assuming whether you are a police or not, while walking, no, in the street, and in your presence you saw one individual stab another person with the use of an ice pick, what will you do? Normally, lalong-lalo na pag pulis, no, na naka-uniforme, magre-react talaga yan at aarestuhin ang suspect na nakita niyang nag-stab doon sa victim. At dito pumapasok ang tinatawag na personal knowledge. Basta in flagrante delicto, matik na yan. May personal knowledge talaga ang police or civilian na umaresto doon sa suspect. Kasi nandoon siya mismo sa actual na pangyayari. Sa civilian naman, depende na lang kung magre-react siya o hindi, no? But generally, meron naman tayong tinatawag na citizen's arrest. Okay, so citizen's arrest is an apprehension of a suspected lawbreaker by a private individual, not a sworn law enforcement officer, no? Under Article 122 of the Revised Penal Code, deals with the prevention of crimes. This article did not directly address citizens' arrest, but it implies a citizen right to intervene to prevent a crime in progress. This intervention may include apprehending the suspect, but the action must be justified and proportionate to the situation. The principle of reasonable force, immediate handover to authorities, and the existence of probable cause are paramount. Okay, next we will discuss the phrase is actually committing or it's attempting to commit an offense. What does it mean? Committing in the context of an offense means the act of performing the physical or mental elements that constitute a crime. This involved both the physical act or the so-called actus reus, and the mental state means rea, no, required for that particular crime. Okay, actus reus or the guilty act. This is the physical component of the crime. Example include striking someone or assault and taking someone's property. As you observe, there is a physical act committed by a suspect against another person. When this happen, you can actually arrest that person. Basta kaya mo lang, pero kung hindi naman kaya, tumawag ka lang ng backup. So ganun lang 'yon. Next is mens rea or the guilty mind. This is the mental element of the crime. It refers to the intent or knowledge the perpetrator had while committing the act. Just like, for example, the crime of murder. The premeditation or intent to kill is necessary to constitute murder. Kung hindi present ang element nito, talagang bababa sa homicide ang kaso. In short, committing an offense signifies the complete fulfillment of the legal requirements, both physical and mental, that define a specific crime under the law. The specific requirements vary depending on the nature of the offense. Attempting to commit an offense refers to taking deliberately actions toward committing a crime, even if the crime is not completed. The intent and substantial step are the key components of attempting to commit an offense. Tandaan niyo yan. For example, buying a weapon with a plan to harm someone. Demonstrate intent, but the preparation of buying a weapon or planning a crime are generally not punishable. Kasi wala pang action. Nagpaplano pa lang. Hindi pa na-execute ang kanyang binabalak. However, when this sabihin natin loaded weapon used by pointing to someone's person, no, tinutok doon sa tao, loaded yung weapon, no, the action goes beyond preparation and show direct move toward the crime. It will now constitute threat to the victim, and it is a clear violation for what crime, no, for the crime of grave threats, no, in relation to Republic Act 10591 or the Comprehensive Law of Firearms and Ammunition. Okay, so that is number 1, no, sa warrantless arrest, in flagrante delicto or caught in the act. Next is the hot pursuit, no, under section 5 paragraph B of the Rule 113 of Criminal Procedure. It states that when an offense has just been committed, and the officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested committed it. The term just committed requires the element of immediacy in the pursuit, and the officer must have direct knowledge linking the suspect to the crime. Okay, what is that hot pursuit operation? Hot pursuit operation is conducted under specific circumstances to apprehend fleeing suspects or prevent imminent harm. In conducting hot pursuit operation, it is important to note that um, that the arresting officer has a take note, no, that the arresting officer has personal knowledge of facts, and the concept of immediacy is crucial because it distinguishes a legitimate hot pursuit from a delayed or planned operation. A significant delay undermines the justification for bypassing the usual warrant requirements issued with arrests and searches. The immediacy requirement ensures that the pursuit is a direct response to a crime in progress or a recently committed offense, not a separate investigation launched after the fact. Meaning to say, you cannot arrest a person during hot pursuit operation if you don't have really you don't really have a personal knowledge to the crime committed by the suspect. Kung wala ka talagang personal knowledge, kahit nasa harapan mo pa yan, ang suspect, still, you cannot arrest that person. To be safe, you conduct further investigation and file appropriate charges in court, no? And that particular suspect, now, kung may warrant of arrest na, saka mo na siya huhulihin. Okay? So, naintindihan. Patungkol naman sa immediacy requirement, no? Immediacy requirement ng hot pursuit operation, no? Una-una, tandaan niyo to, no? There should be no appreciable lapse of time between the commission of the crime and the start of the pursuit. Any significant delay may render the pursuit unlawful. So, ganon katindi, no? For example, arrest made a day, 3 days or 6 days after the crime have been deemed invalid, no? Dapat ang sinabi dito na arestuhin during hot pursuit operation, the arrest made within a day, no? Pero pag maglapse na ng 3 days or 6 days, no? Hindi na matatawag na hot pursuit operation 'yon. Pag inaresto mo pa rin ang suspect, invalid na 'yon. Okay? 'Yun po ang ibig sabihin. Next is there must be a continuity. So 'yun, no? Sabi ko nga kanina na pag naglapse na ng mga ilang araw sa kapana-aresto yung suspect, hindi na natin masasabi na mayroon pang continuity. The pursuit must be ongoing and not interrupted. Yan. If the pursuit is halted, then resume, it may no longer be considered hot pursuit. This ensures the suspect is continuously monitored and apprehended without undue delay. The immediacy requirement safeguards individual rights by ensuring the law enforcement acts promptly and does not engage in delayed or planned operations. This helps maintain the integrity of the pursuit and prevent abuse of the hot pursuit and prevents abuse of hot pursuit exceptions to warrant requirements. Okay, so that is the number 2, no? The hot pursuit, no, operation under warrantless arrest. Number 3, you can arrest a person when Kailan pwede mo siyang i-arestuhin? Kung isa siyang escape, no? Section Section 5, paragraph C of Rule 113 Criminal Procedure, no, states that when a person who has been lawfully arrested or confined, example, serving sentence, detained while under investigation, or while waiting trial, escapes from detention or confinement, then next, the officer or private person may immediately rearrest the escapee without a new warrant. So dito naman, madali lang intindihin, no? As long as the suspect was detained from any jail facility for violation of any crime, then he escapes. No need for you to secure new warrant of arrest. Instead, you can immediately arrest that person. Okay? So, search and seizure will be discussed in the next episode. Hanggang dito na lang. Ah, thank you for listening and for your additional research assignment, no? Please conduct research on the Rule 113 of the revised rules of criminal procedure, no? Ah, kayo na bahala kung ilang pages 'yon. Basta yan ang additional research assignment nyo. So, hanggang dito na lang. Uh, Good day everyone and thank you.